Welcome to the deep dive. Today we're looking into the International Criminal Court, the ICC, covering its journey from 2002 right up to April 2025.
Mm.
Now, you've given us a lot of material on this. It's the first permanent world court for things like genocide, war crimes, and you want the shortcut, right? The key info on the challenges it's faced.
That's the goal, to really distill why this matters for international justice, looking at the hurdles.
Okay, so our mission is to pull out those essential nuggets. We'll hit about 8 key areas: state cooperation, jurisdiction issues, bias claims, immunity, resources, victims, state withdrawals, and that tricky peace versus justice thing. Should be some interesting stuff in here.
Definitely. And I think the core issue, right from the start, has been this built-in tension. The ICC has this huge ambition prosecuting the worst crimes imaginable,
Yeah.
but it has zero enforcement power of its own. It completely depends on countries cooperating,
Yeah.
countries with their own agendas, their own politics.
Right. That tension seems to explain a lot.
It really does. It
Yeah.
shaped almost everything about the court's history.
So let's dive into that first point: state cooperation. It sounds basic, but it's obviously a huge sticking point.
It is. The ICC needs states for everything, making arrests, gathering evidence, protecting witnesses, the absolute fundamentals of any judicial process.
And when they don't cooperate, take Omar al-Bashir, the former Sudanese leader, warrants for genocide, war crimes, serious stuff.
Extremely serious.
Yeah,
And the case was even referred by the UN Security Council itself.
but he still traveled, didn't he, to countries that were actually members of the ICC: Kenya, South Africa, Jordan.
That's right. And they didn't arrest him. They gave various reasons. Some cited head of state immunity. Others pointed to the African Union's position on the warrants.
And what could the ICC actually do about it?
Well, that's the weakness. They found states non-compliant, referred the issue back to the Assembly of States Parties or even the UN Security Council.
But often without much real impact.
Often, yes. It highlighted just how limited the court's enforcement tools are. It's a persistent problem.
And it's not just historical. Look at the warrant for Vladimir Putin over alleged war crimes in Ukraine.
Russia isn't a member state, rejects the ICC's authority completely, even issued its own warrants against ICC officials.
But even Mongolia, which is an ICC member state, didn't cooperate when Putin visited in 2024. They cited immunity.
Exactly. And then you have the very recent warrants requested for Israeli leaders, Netanyahu and Gallant, regarding Gaza.
Also non-members. And the reaction there was quite strong, particularly from the U.S. condemnation.
A very different reaction compared to the West's support for the Putin warrant, which inevitably fuels accusations of double standards, of bias. We even saw France initially suggesting that Netanyahu might have immunity.
It raises so many questions. And we still have Saif al-Islam Gaddafi in Libya at large since 2011, despite a Security Council referral.
And Joseph Kony, the LRA leader in Uganda, warrants out since 2005. His non-arrest has often been tangled up with peace negotiations, which we can talk more about later.
So it feels like this cycle of non-cooperation, especially from powerful states or their allies, just keeps happening.
It does, and every time it happens, it chips away at the court's effectiveness, its legitimacy. It sends a message that, well, maybe impunity can win if you're powerful enough or have the right friends.
Okay, let's shift gears slightly to jurisdiction. Another thorny area, I imagine. The ICC's mandate versus, national sovereignty.
Absolutely. A key point of friction is the ICC claiming jurisdiction over nationals of states that aren't members if the alleged crime happens on the territory of a member state.
Ah, like Article 12.2a of the Rome Statute.
Precisely. And non-member states, like the U.S., historically, strongly object to this. They argue based on the principle that treaties don't bind third parties. Pacta tertius is the legal term. You can't be bound by a club you haven't joined.
So how does the ICC justify it?
Well, there are complex legal arguments, often boiling down to whether the member state is delegating its own jurisdiction, which it always had over crimes on its territory, to the ICC, or if the ICC has some kind of inherent or conferred jurisdiction from the international community. It's a fundamental debate.
And then there's complementarity, the idea the ICC is a court of last resort.
Right. Article 17. The ICC should only step in if a state is genuinely unwilling or unable to investigate or prosecute itself.
But defining unwilling or unable must be tricky. How do you judge if national proceedings are genuine or just a sham to shield someone?
It's incredibly difficult and politically charged. We saw disputes over this with Libya regarding Gaddafi, and it's a factor in the Palestine situation too. The ICC even has a policy now on positive complementarity, trying to encourage and assist national systems.
And the different ways cases even get to the Court Security Council referrals, like Sudan and Libya.
which are criticized for being politically selective, depending on the P5 veto powers, and often come without dedicated funding. Syria is a key example of a situation not referred due to vetoes.
Or state party referrals, like Uganda referring the LRA case, or states referring the Ukraine situation.
Those can raise concerns about political motivations too, or whether they're even necessary if the prosecutor could act anyway.
And then ad hoc declarations, like Ukraine accepting jurisdiction before becoming a full member.
All these different paths create a kind of patchwork jurisdiction, which again opens the door to criticism about why these situations and not others. Even Palestine joining the ICC was heavily contested based on questions around its statehood under international law.
So these jurisdictional fights really highlight that constant push and pull between international legal ideals and, well, state power.
Exactly. And the perceived inconsistencies feed directly into the next major challenge.
Yeah.
Allegations of bias and selectivity.
Yes, the Africa-focused criticism. That was very prominent early on, wasn't it?
It was. For years, all the ICC's formal investigations and indictments were related to conflicts in African countries. This led to strong pushback from the African Union, accusations of neocolonialism, that the court was unfairly targeting the continent.
How did the ICC respond to that?
They pointed out that many cases were actually referred by African states themselves or came via the UN Security Council, and that the ICC acts only when national courts don't complementarity again. But the perception lingered, and definitely strained relations with the AU.
Has that perception shifted now?
Somewhat. While the Africa-focused critique is still heard, the criticism has broadened. Now it's often more about a perceived reluctance to go after powerful Western states or their allies, regardless of geography.
Like the failure to pursue investigations related to the Iraq War, or the scaling back of the Afghanistan investigation.
Precisely. It creates a perception, fair or not, of a two-tiered system of justice, one for some, another for the powerful.
And you mentioned the contrasting reactions to the Putin versus the Netanyahu warrants earlier.
Yes, that really crystallized this critique for many observers. Widespread Western government support for arresting Putin versus outright condemnation, even threats from some of the same governments regarding the warrants sought against Israeli officials.
You hear quotes, don't you, sometimes attributed to officials saying the ICC is for Africa and thugs like Putin, implying it shouldn't touch Western allies.
Those kinds of statements, even if anecdotal, reflect a damaging narrative. It suggests the court is a tool of convenience, not impartial justice, and this directly harms its legitimacy and claim to universality.
And it ties back to operational realities too, right? Dependence on cooperation, on UNSC referral, limited resources of these things inevitably influence which cases are feasible to pursue.
Absolutely. It's a complex interplay. Perceptions of bias aren't just about malice. They can also stem from the very real constraints the ICC operates under. But the result is the same, a potential erosion of trust.
Let's talk about immunity. That seems like a huge legal and political roadblock. Leaders accused of crimes hiding behind their official status.
It's a classic clash. The principle of individual accountability for the worst crimes versus the long-standing international law principle of sovereign immunity, especially for sitting heads of state, heads of government, and foreign ministers, what's called immunity ratione personae.
So what does the ICC's own rulebook, the Rome Statute, say?
Well, Article 27 is pretty clear. This official capacity is irrelevant. Immunities don't bar the court from exercising its jurisdiction. For states that are members of the ICC, they've essentially agreed to waive this kind of immunity before the court.
Okay, sounds straightforward for member states. But what about leaders of countries that haven't joined the ICC?
That's where Article 98(1) comes in.
Yeah.
It says the court cannot ask a member state to arrest someone from a non-member state if doing so would require the arresting state to violate that person's immunity under international law, unless the non-member state waives the immunity.
So that seems like the loophole used in the al-Bashir case. States saying Sudan isn't a member, Bashir has head of state immunity under customary law, so Article 98 prevents us from arresting him.
Exactly the argument used by several states. But then came a key ruling from the ICC Appeals Chamber in 2019 concerning Jordan's failure to arrest al-Bashir.
What did they decide?
They took a strong stance. They ruled, essentially, that Article 27(2), the bit saying official capacity doesn't matter, actually reflects customary international law when it comes to international courts, meaning there is no head of state immunity before international courts like the ICC, regardless of whether the state is a member or not.
Wow. So if there's no immunity to violate, then Article 98 doesn't even apply.
That was the conclusion. They also mentioned the UNSC referral might have implicitly waived any immunity, but the main point was about the lack of immunity under customary law before international courts.
That sounds controversial. Is that interpretation widely accepted?
It's highly debated. Many international law experts disagree with the appeals chamber's finding on customary law, so it creates significant legal uncertainty and political risk for member states.
And we see that playing out now, right? Mongolia invoking immunity for Putin, France initially raising it for Netanyahu.
Yes. The lack of a clear, universally accepted resolution on this issue puts member states in a difficult position when faced with an ICC request to arrest a leader from a non-member state. The ICC stance prioritizes accountability, but it pushes against established norms of state immunity.
Okay, let's touch quickly on operational realities, the nuts and bolts money and logistics.
Right. The ICC is funded primarily by its member states, with some voluntary contributions. But there's constant criticism that it's underfunded, especially compared to, say, the ad hoc tribunals for Yugoslavia or Rwanda. The proposed 2025 budget is around 195 million euros, but some states push for zero growth.
And that lack of funding has real-world consequences.
Definitely. It can compromise the depth and scope of investigations, lead to weaknesses in cases, limit outreach and victim participation programs, and just generally hinder the court's infrastructure. Things like forensic analysis, translation, digital evidence processing, they all cost money.
What about the cases referred by the UN Security Council? Does the UN pay for those?
That was the hope, but it hasn't really materialized. So those investigations, like Darfur and Libya, end up drawing on the regular budget funded by member states, stretching resources even thinner.
And investigating these core international crimes, genocide, mass atrocities must be incredibly complex and expensive anyway.
Hugely complex. You're often dealing with mass violence across large areas, intricate command structures, vast numbers of victims and witnesses, unstable security situations, politically charged environments. Trials can become very long and costly.
Evidence collection must be a nightmare sometimes.
It is. Investigators often work in remote or dangerous zones. Crime scenes might be compromised. Security is a constant concern. The Office of the Prosecutor has put more focus recently on documentary and digital evidence, partly because of these challenges.
And witness protection. That sounds crucial, but also incredibly difficult.
Absolutely critical and very resource intensive. Witnesses and their families can face serious risks. The court's Victims and Witnesses Unit runs programs, but they rely heavily on state cooperation for things like relocation, and budget constraints are always a factor. It's a constant balancing act between protecting witnesses and ensuring fair trial rights for the accused.
So staffing, capacity, security, funding, it all intertwines to impact the quality and fairness of the justice delivered.
Exactly. And it can become a feedback loop. Resource limits lead to perceived weaknesses, which fuels criticism, potentially making states less willing to provide adequate funding. Plus, the nature of conflict and evidence keeps evolving. Think cyber warfare, digital disinformation demanding new skills and resources.
Now let's talk about victims. The Rome Statute was seen as quite innovative here, wasn't it? Allowing victim participation and setting up reparations.
Yes, that was a major step forward compared to previous international tribunals. Victims can participate in proceedings, express their views and concerns, and there's the Trust Fund for Victims, the TFV.
What does the trust fund do?
It has two main jobs. First, it implements reparation orders made by the judges against a convicted person, things like restitution, compensation, rehabilitation. Second, it has an assistance mandate, meaning it can provide support like medical or psychological help to victims and their families in situations the ICC is dealing with, even before a conviction, or if there's no conviction.
That's good in theory. How has it worked in practice?
Well, that's where the criticisms come in. One major issue is effectiveness and timeliness. Reparations processes have often been very slow, and the scale can seem quite limited compared to the number of victims. In the Lubanga case from the DRC, for instance, it took years to get reparations flowing to just a few hundred victims.
Why is it so slow and complex?
Implementing reparations in post-conflict zones is incredibly hard. You have to identify eligible victims, assess complex harms, deal with security risks, manage expectations, ensure cultural appropriateness, coordinate with local partners. It puts a huge strain on the TFV's capacity. And things like COVID-19 or renewed fighting can obviously disrupt everything.
Is funding an issue for the trust fund too?
A big one. The assistance mandate relies mostly on voluntary donations. And for court-ordered reparations, while the convicted person is primarily responsible, their assets are often non-existent or impossible to seize. The TFE can use some of its funds to top this up, but there are significant funding gaps.
There's also debate about the type of reparations, right? Money versus other forms.
Yes. Should it be individual cash payments or more collective or symbolic measures like memorials or community rehabilitation projects? There's also criticism that the focus on punishment in the criminal trial sometimes overshadows the restorative justice goals of reparations. Victims might feel the amounts are insufficient or merely symbolic.
And managing victim expectations must be difficult if the system promises more than it can realistically deliver.
It leads to disillusionment, definitely. And even victim participation in the trials themselves, while important, faces challenges managing large numbers of participants, ensuring adequate legal representation, protection, all without unduly delaying the trial. There have also been criticisms about coordination between the TFE and other parts of the ICC.
So it seems like there's a tension between the laudable goals for victims and the practical, resource-constrained reality of the court's main job, criminal prosecution.
That's a good way to put it. The TFE's dual mandate, funded differently, adds another layer of complexity. Ultimately, its success often hinges on factors way beyond the ICC's walls: security, stability, donor generosity, local partnerships. It highlights the fragility of the system.
Another challenge you flagged is state withdrawals, a threat to the whole idea of universal justice.
It certainly challenges the aspiration of universality laid out in the Rome Statute. As of early 2025, there are about 124 or 125 states parties, but crucially, major global powers like the US, Russia, China, India, they remain outside the system.
And some who joined have left or threatened to.
Yes. Article 127 allows states to withdraw, though it takes a year to take effect, and they still have obligations for the time they were members. Their past actions can still be investigated.
Why do states withdraw?
Various reasons are given. The Africa bias concern led the African Union back in 2017 to adopt a non-binding withdrawal strategy, though many African states opposed it and stayed. More often, perhaps, it seems linked to regimes trying to evade ICC scrutiny.
Like Burundi, they withdrew in 2017 just as the prosecutor was conducting a preliminary examination there.
Exactly. And the Philippines withdrew in 2019 after the ICC started examining Duterte's war on drugs. Sometimes it's framed as a political protest against perceived injustices by the court.
Have any states rejoined after withdrawing or stopped the process?
Yes, South Africa and Gambia both initiated withdrawal proceedings, but later retracted them due to domestic political changes or court rulings. That shows some resilience. But others, like Russia in 2016, unsigned the treaty before even ratifying it. The U.S. also famously unsigned it under the Bush administration, though it had never ratified. Hungary also made moves indicating withdrawal intentions around April 2025.
What's the real impact of these withdrawals?
The immediate operational impact might be limited because jurisdiction over past crimes remains. But the symbolic impact is significant. It signals a rejection of the court, potentially encourages other states to leave, and weakens the international norm against impunity that the ICC represents. It can create a sort of contagion effect.
Though the fact that the predicted mass African withdrawal didn't happen suggests the court still holds sway.
True. The underlying grievances about fairness and selectivity might remain, but the withdrawals themselves haven't crippled the institution. It highlights that these decisions are often driven by specific regimes facing scrutiny, using the bias argument perhaps as political cover.
Okay, final area. This enduring peace versus justice dilemma. This sounds fundamental.
It really is. It's the inherent tension between pursuing criminal accountability for atrocities, the justice part, and the need to end conflicts, often through negotiation, which might involve compromises like amnesties, the peace part.
What's the argument against the ICC getting involved when peace talks are underway?
Critics argue that ICC investigations or warrants can actually hinder peace processes. Leaders or commanders might refuse to come to the negotiating table if they fear being arrested.
They have no incentive to stop fighting if their only alternative is a prison cell in The Hague.
That's the fear. It might undermine local solutions like traditional justice mechanisms or amnesty laws that communities feel are necessary for reconciliation. It could prolong conflict by removing exit strategies for belligerents, or harden positions if one side feels the ICC is biased against them.
Is there a key example where this tension played out?
Northern Uganda is often cited. The ICC issued warrants for Joseph Kony and other LRA leaders in 2005, right in the middle of peace efforts. Some blamed the warrants for Kony ultimately refusing to sign a final peace agreement. Local leaders particularly expressed frustration with what they saw as the ICC's rigidity.
What's the counter-argument? Did the ICC presence help at all?
Well, supporters would say Coney wasn't genuinely committed to peace anyway, and the warrants rightly stigmatized him. The prosecutor at the time, Luis Moreno Ocampo, famously rejected offering impunity as a price for peace, calling it blackmail. Others argue ICC pressure can sometimes marginalize spoilers or even induce parties to negotiate more seriously.
We see similar concerns raised about the al-Bashir warrants and the Darfur peace process, or amnesties given to warlords in places like the DRC, and even now with the warrants sought against Israeli leaders, potentially impacting future Middle East peace efforts.
Exactly. The ICC generally takes a strong stance against impunity for core international crimes. The Rome Statute allows the UN Security Council to defer an investigation for a year under Article 16, but that's rarely used. And the prosecutor has discretion under Article 53 to not proceed if it's not in the interests of justice, but that's almost never been used solely to protect a peace deal involving amnesty.
So the court prioritizes justice, potentially at the expense of peace deals.
That's the core of the dilemma. It's often framed as an either-or, but the reality is usually much more complex. Blaming the ICC alone for failed peace processes often overlooks other critical factors, like the lack of real commitment from the parties involved.
But the ICC's strong retributive justice focus might limit its flexibility in situations where compromise seems necessary to stop the killing.
Yes, there can be a disconnect between the international legal framework and what local populations or negotiators feel is needed on the ground for stability or reconciliation. And this dilemma can also be manipulated conflict parties demanding impunity or external actors using peace versus justice arguments for their own ends.
So, looking back at everything we've discussed, state cooperation, jurisdiction, bias, immunity, resources, victims, withdrawals, peace versus justice, it's clear the ICC faces some really deep, interconnected challenges.
Absolutely. There's this persistent gap, isn't there, between the legal authority the court has on paper and its actual practical power in a world still dominated by sovereign states and their interests.
Hopefully, this deep dive has given everyone listening that shortcut, that clear understanding of these complexities surrounding the ICC. But it definitely leaves us with a big question to think about. Given all these persistent obstacles, these roadblocks we've talked about, what needs to change, what fundamental shifts maybe in the international system itself, or perhaps within the ICC's own approach, might be necessary for it to actually fulfill its mandate more effectively, to really achieve that goal of ending impunity for the world's worst crimes.
That's the crucial question. How do you balance international law, state sovereignty, political reality, and that fundamental